Hi guys, good evening everyone. This is Anish and I'm here on behalf of the National Law Training Institute. You all must know me by now. I am the founder of National Law Training Institute, founded it in 2022. Had a brilliant success over 2 years, CLAT 23, CLAT 24, and now we are back to mentor CLAT aspirants for CLAT 2025. So, एक चीज that every student felt and every parent felt was that mentorship is okay, like it's a supplement to coaching, but they always ask us whether at NLTI we will be covering the basics or like the syllabus. There's no syllabus per se. Ashutosh, you'll also concur with me on this, that there's no syllabus for CLAT, but ultimately parents and students have that apprehension ki whether the syllabus will be covered. So in this aspect, we thought that why not introduce the syllabus coverage aspect as well to NLTI. Till now, our USP was that we provide mentorship to CLAT aspirants by NLSIU students. So we thought, why not people who have cracked CLAT before, who are well versed with all the topics that constitute the syllabus of CLAT, why not they come on screen and take sessions? So today we have Ashutosh, who got an All India rank of 10, has a brilliant grasp over legal reasoning, got a brilliant score in CLAT 24 in the legal reasoning section, and he's here today on behalf of National Law Training Institute to cover the basics of contracts. This is not the last class that he'll be taking. This is a beginning to the series that we call Legal Reasoning Brahmastra, and we will be taking a lot of sessions going forward to cover to ensure complete coverage of the CLAT syllabus for legal reasoning. Over to you, Ashutosh. Feel free to introduce yourself a bit. Tell us why you like legal reasoning so much and why you think you have a grasp over legal, and then go ahead with your slides.
Hey everyone, I hope I'm visible and audible. As I have already been introduced, I'm Ashutosh. I'm from Bhubaneswar, Odisha, and I'm currently waiting for the first trimester at NLS to start in July. So until then, I think this is a great use of my time, and I hope to give some of my wisdom, which I collected during my preparation of legal reasoning section, which is a sort of challenging section of the CLAT paper. I always found it so, it was also the section that really attracted me because it involved a lot of use of your mind. It required the use of logic, and it really needed you to have a really great grasp over whatever the passage is talking to you about. So while the passage in CLAT offers you everything you need so that you can decipher what the correct option is going to be, still having a grasp over the fundamentals is great for you. Law of contracts is one tricky subject in this legal reasoning section. At least I found it so. But I hope I'll be able to simplify it to you and explain it in simpler terms. So let's get started. So we'll be studying about a few basic concepts today, and I'll be having a few passages of those concepts related to them. So I hope you're able to benefit from this section. Let's get started. So before I delve into this technical definition of what a contract is, let me tell you something about the barter system. So as we all know, a long time ago in ancient times, no one really knew the concept of what money was. So there was a farmer who had a lot of mango produce. He wanted rice. So what he did was he exchanged his 10 kilograms of mango with his neighbor for 5 kg of rice in return. But after a while, he sat down thinking, acha, like mango season to chal nahi raha hai, so my mangoes must be more expensive than what the rice in exchange I've got. So eventually people realized that this barter system was not as efficient as they thought it was. So there came the invention of money, and nowadays all our transactions, deals, agreements, everything occurs in this monetary form. So in some way or form, we have all been part of a contract in our lives. So for example, we buy groceries at our supermarket, we offer our money, and in return, we get services in the form of groceries. We go to our salon for our haircut, we do the same. So in every part of the world, contracts are being made. So we don't realize it, but here we are going to delve into the legal aspects of this seemingly ubiquitous stuff that's found everywhere. So the Indian Contract Act 1872 defines what a contract is. It states that an agreement that is enforceable by law is a contract. So let us go into this by thinking about what a contract is actually made up of. So the building blocks of a contract are, firstly, competent parties. We're going to delve into all of these 4 factors later on while we study about the validity of a contract. But let's just focus on what the building blocks of a contract are for a minute. Firstly, we need 2 or more parties who are going to be a part of the contract, among whom the contract is being made. So the competent parties is the first step. We'll decide who the competent parties are. Secondly, we have a lawful consideration and lawful object. The object of the contract must be lawful, and the consideration, that is what one person is paying, what the other is offering, it all must be lawful. Thirdly, free consent. The consent of the parties must be obtained without any duress, coercion, or fraud, misrepresentation, all of which we are going to study about. And fourth, it must not be expressly declared to be void in law. The contract which is being performed, the agreement, must not be against the law. So how does the formation of a contract happen? Pehle, for example, A hai, B hai. A approaches B to offer something जो वो सोचता है कि B will accept. So what A does is A is set to make an offer. जब B agree करता है A के offer को, B is set to make an acceptance. The proposal जो कि A ने दिया था, the offer जो कि B ने accept किया, it becomes a promise. So what A और B एक दूसरे के लिए करने को agree करते हैं, that is the consideration for the promise. For example, I am telling you, I'll sell you my car for 50 lakh rupees. ज़्यादा expensive हो गया. But then what I am doing is, my consideration is, I'm going to give you my car, and what you are doing is, what you are getting from me is the car, so that's your consideration. The 50 lakh rupees that I'm going to get, that is my consideration from your side. A set of such promises is an agreement. पर हर agreement को हम contract नहीं बोल सकते. An agreement that is enforceable in law, मतलब the agreement must have or carry with it a legal obligation. The obligation cannot be merely social or moral. Let's say मेरे दोस्त मुझे बोलते हैं आज 5 बजे मूवी जाना है, and then I do not turn up at the theater. They cannot go to a court and file a case against me. He reneged on his deal, he broke our agreement, because that was merely a social obligation. An agreement which is enforceable in law has to be or has to have an intention to create a legal obligation. And that, my friends, is how a contract is made. I hope this slide has been clear. Next, the first step जो मैंने बोला था, the proposal or the offer. Let us define what an offer actually means. Firstly, when one person or the offerer, जो कि offer कर रहा है, he is called the offerer, signifies to another, जिससे वो proposal जा रहा है, that person is the offeree, his willingness to do or abstain from doing anything. Act or abstinence ऐसे hand in hand चलते हैं in these definitions. So the person who is offering, he is offering what? To do something or to not to do something to the other person, with the view or with a view to obtaining the assent of that other to such act or abstinence. Which hope करता है कि the other person will accept this offer of action or abstinence. And this is the proposal that is being made. What are the essentials for a proposal? Firstly, the proposal must carry with it the intention to create a legal relationship. Proposal ऐसे casual नहीं होना चाहिए. And that उसे समझने के लिए एक story सुनते हैं एक case का, Balfour versus Balfour. So it's a famous case. It was between a husband and a wife. They used to live in Ceylon, which is Sri Lanka today. They went to England on a leave. वो वहाँ घूमे, and then the wife fell sick. The doctors advised her, you stay in England and let your husband go back to Ceylon to carry on his work. So the husband returned, but उसने promise किया था उसकी wife को कि वो हर month उसे 30 pounds भेजेगा, a fixed sum for her maintenance and sustenance in England. But as time went on, उनके पीछे दरारें बढ़ती गई. They had misunderstandings and disagreements. So when the husband was back in Ceylon, after a while, due to the disagreements, he stopped sending the amount of money. The wife took him to court and filed a case against him. The court judged that this was not a contract. This could not be enforceable. The agreement between them was not one that was intended to create a legal relationship. वो तो सिर्फ एक moral obligation था जो कि husband ने उसे बोला था कि हाँ मैं तुम्हें भेजता रहूंगा 30 pounds every month. So this case decided that for a proposal to be valid, to result or culminate in an agreement that becomes a contract, there must be an intention, a prior intention to create a legal relationship or an obligation. Secondly, the contract or the offer must have specific terms. It cannot be vague. The offer must clearly state क्या बेचना है, क्या offer कर रहा है in clear terms. For example, if I have 10 varieties of oil with me and I offer to you, I want to give you oil, and in exchange you give me 500 rupees, this will not be a valid offer because I have not specified what kind of oil I'm going to offer from my inventory. Third condition is the offer must be communicated. The offer cannot just be a mere desire जो कि तुम्हारे मन में है. It has to reach the person to whom you are offering it. To understand this, और एक story सुनते हैं, लालमन शुक्ला versus Gauri Dutt. So what happened in this story was that the person, the defendant, जिसके against case file किया गया था, his nephew had gone missing. So he declared कि मेरे nephew को मुझे वापस पाना है, and he sent his servant उसके nephew को ढूंढ के उसके लिए वापस लाने के लिए. Servant had already gone. Now he declared कि जो भी मुझे मेरा nephew वापस लाके देगा, I'll give you 501 rupees as reward. The servant had not heard of this promise or the offer. The servant came back, he found his nephew और उसको लाके वापस दे दिया defendant को. And when he heard about this कि अच्छा मेरे को 500 rupees मिलना चाहिए मुझे, the defendant he filed a case against the defendant. The defendant said कि I will not be giving you any money. The court ruled in favor of the defendant कि या इधर कोई agreement था ही नहीं, the agreement is void because the offer was not actually communicated to the person who is demanding the money. The servant had no idea of the offer and he had found the nephew on his own, जो कि वो पहले से उसको बोल के भेज दिया था. For example, A proposes by letter to sell a house to B at a certain price. So ये जो proposal है, the offer, इसका communication कब complete होता है? When it comes to the knowledge of the person to whom it is made. So basically, when B receives the letter, the communication of the proposal is complete. Fourth point, another essential of an offer is that it is different from an invitation to offer. So how is it different from an invitation to offer? ऑफर जो होता है उसको इनविटेशन से डिफरेंट होने के लिए क्या चाहिए. So basically हार्वी और फेसी दो लोग थे. हार्वी was probably a person who manufactured rifles and so Harvey was the plaintiff and Facey was the person who was the defendant. So Harvey telegraphed किया Facey को कि will you sell us your rifle and please telegraph us your lowest cash price. Facey ने वापस reply दिया the lowest price of this rifle or whatever it is like 500 rupees, let's say. I'm just simplifying the case. We don't need to exactly learn what the case is. I don't remember it in great detail either. I just remember that it had the invitation to offer as a part of it. So what he thought, the plaintiff who filed the case thought, was that अच्छा ये 500 rupees में मुझे बेचना चाह रहा है, and he said कि I accept this offer. And then Facey said कि नहीं मैंने तो नहीं बोला कि मैं तुम्हें बेच दूंगा 500 rupees में. So what Harvey said is he will take this to court. And the court said that what had happened was only an invitation to offer. There were two questions. Will you sell us this and quote your lowest cash price? The person who replied had only done so to the second question. He had not agreed कि वो बेच देगा. So he had merely invited to offer. When you enter a shop and the shopkeeper has displayed all these items with the price tag, that is an invitation to offer. The offer has not been actually made. The shopkeeper reserves the right कि वो मना कर सकता है from selling. Now, let us delve into a few terms related to offers. There can be many types of offers. So a few that are required from CLAT perspective and I've come across often are, firstly, a general offer. This offer is to the public at large. It can be accepted by anyone who fulfills the terms and conditions of the offer. So ये general offer है कि for example a company declares कि जो भी हमारे products खरीद के उसको एक promo code मिलेगा, will give them a trip to Maldives. Okay, that's controversial. Lakshadweep. So this is a general offer. So anyone who buys the product and finds the promo code is eligible to demand कि हमें वो trip चाहिए, because this was the general offer whose terms and conditions have been fulfilled by any person. A specific offer, however, is made to a definite person. Matlab, it's made to a particular person or a group of persons, and only that person is able to accept it. Next is a counter offer. A counter offer arises when I have made you a proposal, but what you have done is you have not accepted it exactly how it was. तुमने कुछ modifications कर लिया, and then you have sent it back to me. This is not a valid acceptance. You have proposed a counter offer rather. How is a cross offer different from a counter offer? A cross offer arises when A ने B को बोला कि I'll give you 500 rupees में this whatever a car. The B said then B in ignorance, he does not know कि A ने उसे ये proposal भेजा है. B offered to A, ki I'll buy your car for 500 rupees. So what they've done is both parties have stated to each other the same proposal in ignorance. This is not a valid contract because ye dono ne without knowing the other's condition same cheez bheji hai and they'll have to do it again. Next arises a different thing is implied and express offer. So these are two sides of the same coin. What is an implied offer? This offer, as the name suggests, arises from conduct rather than words. ये offer explicitly नहीं बोला गया है. This has been inferred from the facts and circumstances. मतलब ऐसा offer है कि you have not exactly said कि मैं तुम्हें यही दूंगा ये होगा. For example, you are at a railway station and you are having a lot of luggage with you. एक कूली आता है and he picks up your luggage, smiles at you and starts carrying it. You nod at him and then you don't really say anything. You don't accept, you don't reject anything, but you follow him out of the station and then he puts your luggage down and वो पकड़ के तुम जाने लगते हो. The coolie said कि मुझे remuneration चाहिए. When you agreed, मतलब you didn't agree using words, but still your conduct implied that you had accepted the offer of the coolie कि वो तुम्हारा luggage लेके जाएगा. That is an implied offer. An express offer is something where the parties have actually already discussed the agreement beforehand and they've come to terms with a sort set of conditions. For example, I'll give you employment as a sales executive in my company. For that, I offered you this. You will have to reply to me accepting the offer within such and such date through email. If you send the acceptance to me by letter, that will not be acceptable because this is an express offer where the parties have discussed the promised terms and you have to send your acceptance in the same manner. Now we'll delve into acceptance, but before that, I hope there are no doubts. I'll head to the chat section for a second. Yeah, implied offer is valid. It is a valid form of offer. Offer can be either implied or expressed. Does anyone else have any doubts till now? For example, proposal, basics of a contract, what are required for a contract to be made. That will be actually out of your syllabus. How is circumstantial evidence examined? That's a curious question, I accept. But an implied offer is something जो कि case by case basis पे चलना पड़ता है. So there are some situations which genuinely imply कि हाँ offer this person accept किया है, इसीलिए उसने कूली को अपने luggage लेके जाने दिया and he followed him. So next I'll be heading to acceptance. So the next step in a contract is acceptance. Proposal has been made by the offerer to the offeree. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. The offer, when accepted, becomes an agreement. So acceptance कैसे बनाएंगे? Firstly, acceptance को करने के लिए, of course, you have the option of using your words. You can very well say ki, I accept, you have posted a letter and so on. But two more ways where acceptance can be made is that first, by performing conditions. There are some conditions which when you are actually performing them, it is implied कि तुमने acceptance कर लिया है. For this, we'll delve into a story of Carlyle versus Carbolic Smoke Ball Corporation. So ये जो corporation थी, इसने एक smoke ball निकाला था. And what they decided was that by this, if you get influenza, even after using this, will pay you £100. Carlyle, Mrs. Carlyle was a person who read about this offer. She went, she purchased this smoke ball, and then still unhe influenza ho gaya. But the corporation said कि we had not sent you the offer and you had not communicated to us your acceptance. So this is not a valid agreement or a contract, and we are not bound to pay you £100. So of course, जिन्हें influenza हुआ है, she went to the case court and filed a case. So what it was decided here was that this was a general offer, जिसके लिए corporation had set out conditions कि ये purchase करो, ये use करो, अगर influenza हुआ, we'll offer you this much money. So once Mrs. Carlyle purchased it and still she got influenza, contracted the disease, she was eligible to get the £100. So this is a way in which acceptance is made in case of general offer by fulfilling the conditions. Secondly, by receiving the consideration. For example, I come to you and say कि मुझे आपका flat rent करना है. I'll pay you 10,000 rupees advance and per month 5,000 rent दूंगा. इसके लिए I signed and gave you a checkbook. The person जिसको मैंने दिया, you took the checkbook, you encashed it in your bank account. Later on, you cannot say कि मैंने तो offer accept ही नहीं किया था, you cannot stay. Because you received consideration and your conduct amounted to acceptance of the offer. So now your flat has to be rented to the other person. Now, acceptance ko valid hone ke liye, there are a few essentials that are required. What are the essentials? First, the acceptance must be made before the offer that was made in the first place is revoked or rejected. Secondly, the acceptance must be absolute and unqualified. It should correspond with the terms of the offer. जो acceptance है, वो ऐसे offer के terms and conditions को twist नहीं कर सकता. What the offer was, they have to accept it absolutely. Thirdly, it must be communicated in some usual or reasonable manner. Like कभी-कभी prescribed manner होता है कि acceptance ऐसे ही आना चाहिए. अगर ना भी हो तो reasonable or usual way में भेजना है, either postal or electronic mode usually. For example, A ने propose किया था B को कि एक letter लिख के मैं तुम्हें घर बेचूंगा for this much price. B accepts A's proposal sent by post. The communication of acceptance is complete as against A when the letter is posted. See, A ने proposal भेजा था B को that you buy my house for this much price. B ने accept किया. कैसे accept किया? He posted a letter from his side. So the communication of acceptance is complete as against A, जिसने offer किया था, when the letter is posted. B के हाथ से छूट गया ना, तो he sent his letter of acceptance. So acceptance is complete as against A. But the acceptance is complete as against B, जिसने acceptance भेजी है, when वो letter जिसमें acceptance है is received by A. So I hope you understood. The communication of acceptance is complete as against A, the offerer, जिसने वो proposal in the first place भेजा था, when the letter is sent by B. उसके out of hand हो गया, so वो letter of acceptance आ रहा है A के ऊपर. So the moment the letter has been posted, the communication of acceptance against A is complete, but against B, जिसने acceptance accept किया है, that is complete when the letter is received by A. Contract final कब होता है? B के लिए contract final तब होगा जब वो acceptance भेज दिया. Keep in mind, communication of acceptance against B is complete when वो पहुंच जाएगा, वो A पढ़ लेगा और acceptance जान जाएगा. But contract B के लिए final तब होगा when he has sent his acceptance, because उसके हाथ में और कुछ नहीं है. And for A, when the said acceptance letter has been received by him, तब A के लिए contract final होगा. But acceptance के वक्त वो उल्टा था. As against A, communication of acceptance is complete when B has dispatched his letter from his side. As against B, communication of acceptance is complete when the said letter has been received by A. Contract becomes final against B when it has been when he sends his acceptance, because उसके हाथ में नहीं है. और A के लिए contract final होगा जब acceptance letter has been received by him. So this is the letter का धंधा. Instantaneous communication आजकल जो use होता है, like telephone, the contract is complete for both the parties at the same time because instantaneously हो रहा है. So when is it complete? When the acceptance is received by the proposal. And कहाँ पे होता है ये? Made at the place where the acceptance is received. The place of the acceptance where it is received by the proposer, that time, that place is where the contract becomes complete. Revocation क्या होता है? किसी चीज को करने से मना कर लेना or we are withdrawing it. So A ने जो proposal भेजा था B को, वो कब तक revoke कर सकता है? At any time before or at the moment when B posts his letter of acceptance. B अपना letter of acceptance भेजने से पहले I can revoke my offer. B जिसने acceptance भेज लिया है, उसके लिए revocation तब होगा at any time before or at the moment when the letter communicating the acceptance reaches A. Other modes of revocation are also there. For example, lapse of time prescribed. अगर ऐसा लिखा हो contract में कि, for example, you will have to reply within a week and there has been no response of acceptance, then of course the offer has been revoked. अगर ना भी prescribed हो, then there must be a lapse of a reasonable amount of time, like 5 years हो गया, acceptance नहीं आ रहा, so that's obviously the offer stands revoked. Failure to fulfill a precedent condition. Kabhi we have a condition which you have to fulfill for the offer to work. So if it's not being fulfilled, it can be revoked. If the fact of death or insanity of the proposer comes to the knowledge of the acceptor before acceptance. Proposer जो भेजा था, वो acceptor acceptance करने से पहले जान गया कि the proposer is either gone insane or has died, then that is revoked. So I think this part is a little confusing and we'll clear it up with the help of this question. So let's start reading gradually, and keep in mind you did not pay attention to each and every line if it's a long passage. This one's a short one, so it's pretty sure that every line matters. So section 4 of the act reads as follows. Communication when complete, the communication of a proposal, just जो offerer भेजता है, the proposal is complete when it comes to the knowledge of the person to whom it's made. Proposal भेजा, वो दूसरा बंदा जाना, and then the proposal is completed. Acceptance कब complete होगा? Acceptance जो proposer है उसने भेजा है proposal, अब जिसके पास गया है, the acceptor has the power to accept. So as against the proposer, जो कि मैंने बोला था A और B के केस लेके, as against the proposer, it is complete when it is put in course of transmission to him so as to be out of the power of the acceptor. So A और B के केस में जैसे था, the communication of acceptance is complete against A when B has sent his letter of acceptance. It is out of the power of the acceptor. Against acceptor कब complete हुआ? Against B कब complete हुआ? When the letter of acceptance is actually coming to the knowledge of the proposer, who is A here. Thus, the provision makes no difference in the position of the offerer. The offerer becomes bound when a properly addressed and adequately stamped letter of acceptance is posted. The acceptor does not become bound by merely posting his acceptance. He becomes bound only when his acceptance comes to the knowledge of the proposer. ये इतना important part नहीं है, question में usually use नहीं होगा. The contract is concluded at the place from where the proposal is accepted and communication of acceptance is dispatched. A और B याद रखो. A ने proposal भेजा था B को, B communicated his acceptance. So the place where B accepts the proposal and communication of acceptance is dispatched, the address to which the proposal was sent, that is the place where the contract is concluded. Keep this in mind. The court at that place would have jurisdiction to entertain a cause of action under the contract. So I hope you understand that B के जगह जहां से वो acceptance का dispatch किया था and where the contract was concluded, that is the place where the court has the jurisdiction to entertain a cause of action under the contract. This rule that the communication of an acceptance is complete as against the proposer when the letter of acceptance is posted is probably intended to apply only when the parties are at a distance and they communicate by post. Where, however, the parties are in each other's presence or though separated in space, they are in direct communication, as for example by telephone, no contract will arise until the offerer receives the notification of acceptance. मैंने बोला था वो जो post and letter का धंधा है, that comes into play when A और B दोनों दूर जगह में हैं and they are doing it through letter or mailing, right? So communication of acceptance against proposer तब complete होगा जब acceptor dispatch किया, against acceptor तब complete होगा जब proposer जाना. When it is instantaneous or direct communication, for example by telephone, contract तब तक नहीं होगा जब तक offerer को notification मिल जाए acceptor का, so तभी होगा. So now let's do the question and I hope you'll be able to understand. So S wanted to purchase shares of a company and communicated his offer to buy shares on 1st of March 2021, right? So S को एक company में shares खरीदना था and he sent his offer. He is the offerer or the proposer, जो भी कह सकते हो. He communicated his offer to buy shares on 1st of March 2021. A letter of allotment of shares addressed to S, which is an acceptance, the offer of the offer to purchase shares was posted by the company on March 10. March 1st को S ने proposal भेजा कि I want to buy shares. Company accepted and sent the letter back on March 10th, right? But the letter never reached S and was lost in transit. In the given situation, which of the following statements is true? So जो acceptance का letter company ने वापस भेजा था S को, it never reached S. But the company had already dispatched the letter of acceptance and it was out of its hands. So इसके लिए हमने क्या पढ़ा था? The communication of acceptance is complete, coming back to the paragraph, as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor. मतलब here the communication of acceptance is complete against the proposer. Proposer कौन था? S था. So S had proposed, even though it never reached him, it was sent by the company. The acceptance was dispatched and it was out of their powers. The communication of acceptance is complete as against S. However, not complete as against the company. Option B is the correct answer. I hope you understood how. Because company ने जो भेजा था, it never came into knowledge of S. It was lost. That is why communication of acceptance is not complete against the acceptor, because as the paragraph says, it is complete as against the acceptor when it comes to the knowledge of the proposer, right? Next question. A, who is in Mumbai, makes an offer for supply of goods to B, who is in Delhi, via a mobile phone call. During the same call, A's offer is absolutely and unconditionally accepted by B. So A Mumbai में है B कहाँ है? दिल्ली में है. Call किया है and A offered कुछ goods supply करने के लिए B को, and B accepts it absolutely and unconditionally during the same call. According to the terms agreed between A and B, goods are to be supplied at Pune and payment is to be made electronically. So where is the contract concluded? Remember, contract is concluded at the place where the proposal is accepted and the communication of acceptance is dispatched. So तुम्हें लगेगा कि A ने proposal भेजा था, B ने accept किया, so B ने dispatch किया, so दिल्ली में complete हुआ होगा and वहाँ के court के jurisdiction होंगे. But that is where you will be wrong, because the question talks about a mobile phone call. So as the last line suggests, when the parties are, though separated in space, they're in direct communication by telephone, no contract will arise until the offerer receives the notification of acceptance. So here it's a telephone call. A is in Mumbai, B is in Delhi. B ne accept to kiya, but the acceptance is actually complete, or the contract will arise when the offerer, matlab A, who is in Mumbai, receives the notification of acceptance, and that is why the contract is concluded at Mumbai. Keep in mind that this is a different case from the one that's addressed in the first half of the second paragraph. 78th question. It might be a little small. I'll read it out for you and I hope you'll be able to understand. X Gandhinagar mein hai. He or she makes an offer for a sale of second-hand luxury car to Y, who is in Jammu. So X sent an email to Y on 15th of January 2021. So this is from CLAT 2021. I've picked up only passages from previous year papers. So X is in Gandhinagar. He makes this email to Y on 15th of January at 2:03 p.m. So 2:03 हुआ है. X's offer is absolutely and unconditionally accepted by Y via an email sent on January 15, the same date. Ignore the date. Don't lose time in going through unnecessary information. So as I'm explaining, I'll be slower, but I hope you'll be fast soon enough. So at 4:04 p.m., X ka offer Y accept karta hai, and he also sends an email back. The email communicating acceptance is read by X same day, 7:05 baje. So in this given situation, when is the contract concluded? So देखो, contract conclude कहाँ बोला था? Here. So the contract, the acceptor does not become bound by merely posting his acceptance. He becomes bound only when his acceptance comes to the knowledge of the proposer, right? So X ने initial भेजा था. X sent this offer of a second-hand luxury car to Y email में 2 बजे. Y ने accept किया 4 बजे and भेज दिया. So the contract is concluded as against X. X, the proposer, communication of acceptance is complete against him at 4:04 p.m. But Y के लिए contract कब conclude हुआ? When it comes to the knowledge of the proposer. देखा, the acceptor does not become bound by merely posting his acceptance. Acceptor मतलब Y के against contract तब conclude हुआ when X read the email at 7:05 p.m. And that is why A is the correct option in 78. 79. X is in Agra. He offered to sell something to Y, who is in Jammu. Email send kiya, same date, 2-3 baje. The email did not reach Y due to some technical error at the server, which is located in Delhi. So X ने email भेजा था, वो नहीं हुआ. अभी वो call कर रहा है. Let's forget about the email. X makes a mobile phone call to Y at 4:04 p.m. and makes him the same offer that was made in the email, right? In the same mobile phone call, the offer is absolutely and unconditionally accepted by Y at 4:10 p.m. So 4 baje X ने phone call किया and makes him the offer. 4:10 baje Y ने accept कर लिया. Keep in mind, this is a phone call, a telephone. That is why here the contract will arise only after the offerer receives the notification of acceptance. So offerer कहाँ है? X आगरा में है. This question is similar to the one in 77 as well. So since X आगरा में है, उसके against communication और offer contract सभी complete तब होगा जब X Y का acceptance जान जाएगा. And that is where is it? X is in Agra, so that is the place where the contract is concluded. When the words of acceptance are spoken into the telephone, they are put in the course of transmission to the offerer so as to be beyond the power of acceptor. I've already told about this a lot of times. The acceptor cannot recall them. So which of the statement is true? The communication is being instantaneous. The contract immediately arises. See, ये telephone है. Telephone मतलब You are holding the phone, the other person accepts your proposal. That means the communication is instantaneous. The contract immediately arises. The person, the offerer, has come into knowledge of the acceptance. Right. So the first statement is correct. Communication being instantaneous, the communication of acceptance is immediately complete as against the proposer as well as the acceptor. ये mail post letter का problem नहीं है. This is about telephone, right? So the contract immediately arises, and yes, the communication being instantaneous, acceptance proposer के against और acceptor against दोनों का against same time में complete हो चुका है. That is why the first and second statements are right. The third and fourth statements are not right because the communication has been called non-instantaneous. So I'll check for some doubts. Does anyone have any doubts? Sure, Anshul.
So which book you are referring?
This is not a book actually. This is CLAT 2021's question paper, and I searched for contract passages from previous year papers, and I'm using questions from them.
Fine, sir.
Sure. Does anyone else have any confusion about the questions? Okay. Let's head to the next one. So now we'll be going into a different topic, validity of a contract, right? So contract valid kab hota hai? Firstly, competence of parties. As I talked to you about, there were 4 things that I talked to you about: competence of parties, lawful consideration and lawful object, free consent, and not expressly declared void in law. So now we'll be talking about those 4 building blocks of a contract and how these blocks combine to make a contract valid, right? So firstly, competence of parties. When a party is competent to conduct or to be a part of a contract, when they have the age of majority. So contract with a minor is void ab initio. What does that mean? It is void from the starting. A minor is not eligible to be a party to a contract. So you need to have attained the age of majority to be a competent party for a contract. The minor cannot either confirm an agreement made by him during minority on attaining majority. तुम ये नहीं कह सकते कि now I have become a major and now I'll be able to confirm जो मैंने किया था minority के वक्त. You will have to make a fresh agreement for it. The minor, however, can always plead his minority despite earlier misrepresenting to be a major. So even though minor ने भी मतलब कुछ बदमाशी करके पहले बोला था कि no, I am a major, and he had misrepresented himself, he'll still be always able to plead his minority. Contracts done with minors for supplying necessities to life are valid contracts. Contract minor के साथ तभी valid होगा when it is about supplying necessities to life. Just a few facts. If you're familiar with such things, you'll be able to read passages a lot faster. Secondly, sound mind. If the person is capable of understanding the contract and forming a rational judgment as to its effect upon his interests. So sound mind किसे बोलते हैं? The person is capable कि a contract क्या है, and he is able to form a rational judgment कि ये contract का effect मेरे interests पे क्या होगा. So when is this the case? A person who is a patient in a lunatic asylum, he or she will only be able to be a party to a contract when he is of sound mind. मतलब अगर वो intervals में sane हो रहा है, then during those intervals only he is able to do a contract, right? A man who is drunk, मतलब इतना drunk he does not understand his own interests and the contract, he or she cannot contract. These were examples of sound and unsound mind. Thirdly, the party must not be disqualified from contracting by any law. An insolvent person, जिसके पास मतलब नहीं होता है property and all, they are bankruptcy. They are actually not eligible to participate in a contract or a contract with an alien enemy or a foreign sovereign. These are all contracts which are void because you are disqualified from contracting with. Next, the second condition for a contract to be valid is lawful consideration. Now let's talk about what consideration is. I'd given you a brief overview beforehand. When at the desire of the promiser मतलब जो promise कर रहा है, the promisee जिसको promise किया गया है has done or abstained from doing something, such act or abstinence is called a consideration for the promise. A ने B को promise किया, B is a painter, कि if you paint my house, I'll pay you 700 rupees. कंसिडरेशन फॉर ए क्या है? ए को क्या मिल रहा है इस कॉन्ट्रैक्ट में से? उसका हाउस पेंट हो जा रहा है. B के लिए क्या मिल रहा है? B को वो 700 rupees देगा. So that is how B gains from this. B can sue for breach of contract if A does not pay. This contract has been finalized. There is a consideration for both of the parties. The parties are competent. There is a free consent. So now if A refuses to pay and reneges on his deal, B can file a lawsuit against him for breach of contract. Ranjan promises to give Rani a sum of rupees 10,000 but later refuses. No lawsuit can be filed as no consideration was involved in this situation. So this is a different situation. Ranjan promises to Rani कि मैं तुम्हें 10,000 रुपए दूंगा, but later वो मना कर लेता है. Rani cannot file a lawsuit claiming 10,000 because there was no consideration for Ranjan here. वो तो सिर्फ एक ऐसा ही promise कर लिया था कि हाँ मैं तुम्हें दे दूंगा. No lawsuit can be filed as no consideration was involved in the situation, without which the contract is void. So the consideration can be of broadly of two types: past or executed consideration, future or executory consideration. Past मतलब A बोलता है मेरा handbag loss हो गया, and the one who returns me, I'll give you 50 rupee reward. So there is something that has already been lost and B has already found it, and if he finds the returns, and B's consideration is executed. So उसको मतलब 50 rupees देना होगा. Future or executory consideration मतलब क्या? A ने promise किया है B को कि I will deliver goods to you on a future date, and B promises to pay on delivery. So A का consideration execute हो जाता है delivery pay, right? So अगर A deliver नहीं कर पाता है, that will become a breach of contract. So now, before delving into the next exceptions part, the main issue for a contract to be valid, मतलब contract valid होने के लिए जो हमें lawful consideration चाहिए, it's only presence. It is not its inadequacy. याद रखो, for example, A के पास एक घोड़ा है. A agrees to sell a horse worth 10,000 rupees. मतलब let's assume कि वो horse का worth 10,000 rupees है, लेकिन A ने agree किया है free consent के साथ B को वो 10,000 रुपए का horse 10 रुपए में देने वाला है. This agreement is still valid and the contract is still made because it is a contract notwithstanding the inadequacy of the consideration. The court will not sit down to measure whether the business is fair or whether the consideration of on both sides is fair. So they'll only look at free consent and lawful consideration and lawful object. Exceptions. कुछ cases में contract बिना consideration के भी enforceable होता है. When is it? Firstly, natural love and affection. Let's say A अपने son को promise करता है out of his natural love and affection that I'll give you 1,000 rupees and puts it in writing and registers it. So this makes it official. This is a contract. Even though son उसके बदले कुछ दे या ना दे, there is no consideration for A here. A is only promising to give 1,000 for the son, but still this is a contract. Another exception here is compensation for voluntary services. A ने कुछ बोला नहीं था and A का पर्स B मतलब B का पर्स A फाइंड करके B को दे रहा है, and then B promises कि ये voluntary service जो तुमने मेरे लिए किया, I will compensate you by giving you rupees 50. This is a contract provided that the promise was made by the promiser voluntarily. So B ने जो A को बोला 50 rupees वो दे देगा. This is a compensation out of voluntary service. So this will still be valid. These are only two exceptions, but broadly you need to have a consideration for a contract. Next part is lawful object. The objective or the goal of a contract must be lawful. कब lawful नहीं होगा? The following agreements are void. Void how? Agreement in restraint of marriage. So marriage in our society is considered a very sacred thing, and it is required for the sustenance of race and the systems around us. So it is something immoral to restrict someone from getting married using such a contract. So I'll pay you 1,000 rupees if you do not marry anyone. That is an agreement in restraint of marriage, and it is not valid. It's void. So this object is not lawful except when the marriage is being conducted of a minor. Secondly, restraint of trade. As in our country, there is an absolute fundamental right to have your free trade. So any right that any agreement or contract that encroaches upon this right is void. One party agreeing to close his business in consideration of the promise by the other party to pay money, this is illegal. I have a school, you have a school, I pay you 1 lakh rupees and tell you to close down your school so that I'll be benefiting. This is not a lawful object, and such an agreement is void. Legal proceedings के restraint में, अगर I'm making you a party to an agreement where I'm saying कि we both cannot go to any court to settle our disputes, we'll have to talk among ourselves only. This is a restraint of legal proceedings. You cannot do so. Everyone has, the aggrieved party has the right to approach a court for necessary redressal. The exception in this case is अगर उसने और उन्होंने contract में decide किया है the agreement is to refer to arbitration, मतलब वो कोर्ट ना जाके arbitration करके अपने मैटर को सुलझा लेंगे, and only the amount awarded in such arbitral tribunal shall be recoverable. Is that's not void, that's totally valid. Public policy or good morals के restraint में. So if the agreement is in restraint of public policy or good morals, then this is void. For example, A agrees to let her daughter to be for concubinage, मतलब mistress बनना. So this is immoral and this is not allowed. That is why this is in restraint of public policy बोलते हैं. Sorry, that's a restraint of morals. A promises to drop a court case against B for robbery, and B promises to restore the value of things taken. This is also void. You have stolen few things from me, and I'll say कि अच्छा मैं case नहीं करूँगा. You have already filed a case and you're promising to drop it, तो मुझे वापस दे दो सर. This is something that is stifling prosecution. Prosecution is a duty in any crime that is actually committed is a crime against the state, and that's why the state has the right to prosecute the criminal. But if you are making this quid pro quo between yourself, it is against public policy, and such an agreement is void. As we have also seen in a lot of curious news cases, the person who is being convicted of rape is being asked to marry the victim, and somehow as if that would reduce the severity of their crime. That is also a void agreement. Once you have committed such a crime and a case has been filed, the prosecution has a right to ensure that you get your conviction. Next, uncertain agreements. Uncertain agreements, matlab I have suppose 10 varieties of oil, and you ask me ki, give me this much liters of oil, by this much I'll pay you this much into thin air. A bolta hai ki I'll discover a treasure of magic if you give me 500 rupees. All these things are impossible acts, and an agreement to do so are void. There is no lawful object here. Agreements forbidden by law क्या होता है? Bribery सोचो. A promises to B कि मैं तुम्हें public service में employment दिला दूंगा, सरकारी नौकरी दिला दूंगा, and B promises कि मैं 10,000 रुपए उसके बदले में तुम्हें दे दूंगा. This is bribery. This is forbidden by law, and such an agreement is void. So these are a few examples जहाँ पे lawful object नहीं होता है. This is a topic where जो नहीं होता है वो जानना ज्यादा important होता है. Lawful object you will automatically decipher कि अगर agreement is not a part of any of this, then it's lawful. So now we'll move to a few questions.
So excuse me, I have a question.
Sure, go ahead.
So my question about contracts is confusion which I commonly have is regarding verbal contracts. To what extent are verbal contracts applicable? Because I see those in questions and get confused. So could you just guide us with regard to that?
Yeah, verbal contracts are perfectly valid. Contract can be in writing or can be through oral words. Your contract's acceptance can be implied as well as expressed. So all of this sounds a little fishy, like how can oral contracts be valid? But yeah, they are actually valid verbal contracts.
So there was a provision written in your notes regarding natural love and affection. In that, an example was given regarding a dad agreeing to pay his son 1,000 rupees due to natural love and affection, and it will only be valid if he writes it in writing and registers it. So in this case, would an oral contract be valid? If suppose I tell my friend that okay, I'll give you 1,000 rupees, would such a contract be valid?
If such a comment is made in like passing in a casual manner, that perhaps would not be valid. Keep in mind that this was the contract where there was no consideration as such. The father was just agreeing to give 1,000 rupees to the son. So that he registered it and made it in writing as well. So that becomes a contract. But for example, if it's an oral case, I'm telling you that I am offering you, I'll sell you my car to you for 5 lakh rupees, and you are agreeing that yes, I will pay 5 lakh rupees for your car. This is a valid contract, the oral form, the verbal form. But as such, there was no consideration in that case, and perhaps that's why he had to register it in writing and ensure that this became a contract.
Yes, sir, thank you.
Manan?
Yeah, so what is the difference between an object and a consideration?
Yeah, so object is basically what your agreement purports to do, the goal of your agreement. For example, I talked about the agreements which are void. If your object of the agreement is to restrain someone from marriage, if it's to restrain someone from carrying out their trade or going to legal proceedings, that is your unlawful object. Your object is the goal of the agreement, whereas the consideration is what you give to each other in exchange. A and B agreed. A agrees to sell his car to B, and then B agrees कि मैं 5 lakh rupees दे दूंगा. So the car is the consideration for B. 5 lakh rupees is the consideration for A. That is what you are offering to each other in return, without which a contract will not be valid.
Got it. So, in a sense, consideration is the monetary terms in which a
it can either be monetary or
contract
whatever services
is
act or
evaluated,
abstinence.
and the object is somewhat similar to intention, I guess.
Yes, sure. The intention here
All
is to
right.
create
Thank you.
a relationship, is to ensure that the car gets sold. So there is a lawful object and there is a lawful consideration for it. All right. So the passage starts off saying, it is a well-settled principle of contract law that parties cannot by contract exclude the jurisdiction of all courts. I've talked about this. Agreements and restraint of legal proceedings are illegal, right? So they are void. Such a contract would constitute an agreement in restraint of legal proceedings and contravene Section 28. However, where parties to a contract confer jurisdiction on one amongst multiple courts having proper jurisdiction, to the exclusion of all other courts, the parties cannot be said to have ousted the jurisdiction of all courts. समझाता हूँ. So parties, दो parties हैं contract में, उनके पास options हैं multiple courts के jurisdiction के. सारी courts के proper jurisdiction है. What they can do in their agreement is that they can decide कि मैं बाकी courts नहीं जाऊंगा, and they can choose one of the courts which has the proper jurisdiction and ensure that their dispute is filed there. Such a contract is valid and will bind the parties to a civil action. So, itna khatam ho gaya, and then he is going off to Section 28 of the Indian Contract Act. Remember, agreements in restraint of legal proceedings, void. Which agreement is in restraint of legal proceeding? Every agreement by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by the usual proceedings in ordinary tribunals, or which limits the time within which he may thus enforce his rights. So this is also CLAT 2022, if I remember correctly. So what he's saying is, जो भी agreement अब एक party को restrict करता है absolutely from enforcing his rights. Enforcing rights कहाँ? Under or in respect of any contract. Whenever you, for example, where does the need for a contract arise? When you are trying to make deals, arrangements between yourselves, you need to have a set of rules so that you know what your rights with respect to the agreement are, what your obligations are, what your liabilities are, and in some rights को enforce करने के लिए you have the option of approaching some due course of justice. But here, if by usual legal proceedings in ordinary tribunals आपको नहीं करने देते हैं वो, or which limits the time, मतलब तुम्हें time दिया है कि तुम 6 months तक ही इस contract के लिए you can file a case in any court. That is also void. So a party, if it's restricted absolutely from enforcing his rights under a contract by usual legal proceedings in ordinary tribunals, or जिसके लिए time restrict कर रहा है, that's void. Another point is that every agreement which extinguishes the rights of any party thereto, or discharges any party thereto from any liability under or in respect of any contract on the expiry of a specified period, so as to restrict any party from enforcing his rights, is void to the extent. So यहाँ पे वो ये बोल रहा है कि if it is extinguishing the rights of one of the party or is discharging it, कि तुम्हें कोई liable नहीं बना सकता after the expiry of a specified period. एक पार्टी को वो ऐसे immunity दे दे रहा है and दूसरी पार्टी की rights enforce नहीं कर पा रहा है, that is also void to this extent. So parties cannot by agreement confer jurisdiction on a court which lacks the jurisdiction to adjudicate. Remember, मैंने बोला था कि if there are multiple courts which have the necessary jurisdiction, the parties can go for one of them which has proper jurisdiction. But they cannot by agreement confer jurisdiction on a separate court which does not even have the jurisdiction to adjudicate. So where several courts would have jurisdiction to try the subject matter of the dispute, they can stipulate that a suit be brought exclusively before one of the several courts to the exclusion of the others. The same point is being repeated. जहाँ बहुत सारे courts के पास jurisdiction होगा subject matter try करने के लिए, they can stipulate that उनमें से एक court के सामने you can bring the suit. The first question. A is a resident of Mumbai, B is a resident of Delhi. They enter into agreement for sale and supply of goods. The transaction takes place partly in Mumbai, partly in Delhi. So what does this tell you? Mumbai and Delhi both have the proper jurisdiction for the case. Clause ये बोलता है कि dispute होने में courts in Kolkata would have exclusive jurisdiction to decide the dispute. A and B agreed to the said clause to avoid dispute over choice between the two proper places of jurisdiction. So which of the statements is true? I think you have already got the point. Mumbai and Delhi's courts have the proper jurisdiction. What they have done is they have conferred jurisdiction on Kolkata. As the last paragraph clearly states, parties cannot by agreement confer jurisdiction on a court which lacks the jurisdiction to adjudicate. So here the option is A. The clause relating to jurisdiction is in restraint of legal proceedings. 82. A resident of Chennai and B, a resident of Bengaluru, enter into an agreement for sale and supply of goods. The transaction takes place partly in Chennai, partly in Bengaluru. There is a clause in the agreement which stipulates that in the event of a dispute between A and B, the courts in Chennai would have exclusive jurisdiction to decide. They have agreed both. So see, Chennai and Bengaluru both have proper places of jurisdiction, and as such, the clause is valid as courts in Chennai have jurisdiction to decide the dispute. D, simple. 83. A is a resident of Agra, B is a resident of Bhubaneswar. They enter into an agreement for sale and supply of goods. Transaction takes place partly in Agra, partly in Bhubaneswar, so both the places have necessary jurisdiction. But the clause states that in the event of a dispute between A and B, neither of them can approach the court of law or take recourse to any alternative dispute resolution mechanism. Alternative dispute resolution mechanism usually talks about arbitration, negotiation, mediation, and so on. They are also valid forms of recourse. But here what they have done is they have completely shunned off this option of going to any court of law. So what the given situation tells you is that the clause relating to jurisdiction is not valid as it is in restraint of legal proceedings. What option C tells you is that clause related to jurisdiction is valid as they have not restricted the choice of either party regarding choice of jurisdiction. Choice of jurisdiction na bhi karo, but you have clearly, what you've done is the point A. You have restricted absolutely from enforcing your rights in ordinary tribunals, right? So next question. A resident of Ahmedabad and B, a resident of Ranchi, enter into an agreement for sale and supply of goods. The transaction takes place partly in Ahmedabad, partly in Ranchi. Both the places have necessary or proper jurisdiction. What here the clause 6 states that within 6 months of entering into contract, they can approach a court in either Ahmedabad or Ranchi, as both are other places of jurisdiction, or take recourse to alternative dispute mechanism to settle the dispute. Clause 6 ये बोल रहा है कि contract के 6 months में, मतलब within the 6 months, you can go to either Ahmedabad or Ranchi or ADR. What clause 6 is saying, in the event of a dispute arising between A and B after the expiry of 6 months of entering into contract, courts in Chennai would have exclusive jurisdiction. So you can clearly see कि यहाँ पे तो Ahmedabad और Ranchi के पास ही proper jurisdiction है. Clause 7 is clearly wrong as courts in Chennai के ऊपर confer करना jurisdiction is wrong because it does not have the proper right. Now let's decide about clause 6. Clause 6 states seemingly कि हाँ वो कर सकते हैं जो भी करना है within 6 months. But what the second point says here is that which extinguishes the rights. The first point, the second part, or which limits the time within which he may thus enforce his rights. So after 6 months, वो allow कर रहे हैं चेन्नई में, which is not true. So clause 7 is void, but clause 6 here is also void because this time limit that you are putting on yourself, कि 6 months तक you can, and then you can't do it in Ahmedabad or Ranchi, और Ahmedabad और Ranchi में अगर नहीं कर पा रहे हो, then और कहीं जाके करो, that's illegal. मतलब that agreement is void. So in the first place, both clause 6 as well as clause 7 are void, and the correct option is D. I hope everyone is clear.
So excuse me, if the question was slightly tweaked to make it first 6 months Ahmedabad, next 6 months Ranchi, would such a contract be valid?
But what matters is what after that. Like if you are dividing the time between Ahmedabad and Ranchi, both the places have proper jurisdiction for your for the case to be filed. But if you're meaning that after the expiry of a certain period, you cannot do so, or whether you after the expiry of a certain period, you are conferring jurisdiction on Chennai, that would not be legal. That agreement would be void. You can alternate.
Suppose the contract is like made for a year only. I'm just assuming in this case.
Achha.
So in that case, 6 months, would that be valid?
I think that would be valid because you have not restricted yourself from legal proceedings. As they had already said, you can confer jurisdiction on one amongst multiple courts. So what you're doing is for 6 months, you're conferring jurisdiction on Ahmedabad, and then for the next 6 months in Ranchi. Both the courts have proper jurisdiction, and such a agreement will probably be valid.
Okay, thank you, sir. Thank you.
You're welcome. Now, the last point of validity of a contract, free consent, when both parties agree upon the same thing in the same sense, consensus ad idem. So what this phrase means is that The parties have to consent, but what they are doing is the agreement must be in the same sense and about the same thing. A few vitiating factors, factors which actually go against free consent and therefore make the agreement either void or voidable are, firstly, coercion. What's coercion? Committing or threatening to commit any act forbidden by the Indian Penal Code. The act may be physical force or intimidation, unlawful detaining or threatening to detain any property with the intention of causing any person to enter into an agreement. Such an agreement is voidable. So coercion is when मैं तुम्हें धमका रहा हूँ and I'm threatening you you have to agree to sell your house to me for 1 lakh rupees. Otherwise, I'll beat up your family, or otherwise I'll detain your let's say your car. And all these things are with the intention of causing the other person to enter into an agreement, but not out of their free consent. So such an agreement is voidable. So let me tell you a little bit about what void and voidable means. Void agreements, they are unenforceable from the starting. They are void and they cannot be enforced under law. But voidable agreements are valid until the party that at option of whose the agreement can be voided, until they choose to void it, the agreement will stay valid, right? So such an agreement is voidable. Voidable at whose option? The party whose consent was so vitiated. So the party who has been intimidated, once they approach a court to free themselves of such a contract which was obtained out of them using coercion, the agreement will be voided instantly. Secondly, we have undue influence. When one person is in a position to dominate the will, holding real or apparent authority, for example, master and servant, fiduciary relationship, example, doctor and patient, solicitor and client, and other person's mental capacity being affected, enters into a contract with him. That position is being abused to obtain an unfair advantage over the other. So you see, undue influence is not the same as coercion. Coercion means you have no relation with each other, but one person is threatening or committing some kind of act which is against the criminal code here of India. And here, the undue influence is that there is no crime being committed, but the person, one of the persons, is in a position to dominate or influence the other person. How? Because either the person is, for example, the master and servant. If you have a teacher and a student, if you have a solicitor and a client, one of the person is holding a lot of influence and leverage over the other person. So, for example, if one of the person's mental capacity is affected, so in such contracts, the position, if the person who is powerful and influential uses it to obtain an unfair advantage, this contract becomes voidable at the option of the party whose consent was so vitiated. Thirdly, we have fraud. Fraud is the suggestion of an untrue fact. Fact, not opinion. A person, suppose I'm stating that this is basmati rice, best quality, buy it from me. Whereas I know that this is really low quality rice. So I am suggesting a fact which I know that it's not true. It cannot be opinion. I may say, I think this is the best cloth you can find for 500 rupees. That would not be fraud because that is only an opinion. But if I'm stating a fact so as to induce you with the intention to deceive you so that you will buy into this agreement and you will become a part of this contract, that is fraud. So let's read ahead. Suggestion of an untrue fact by one who does not believe it to be true. Active concealment of a fact by one having knowledge or belief. I know what I'm selling you is defective and you've asked me if it's defective, but I'm not saying you anything about it. Or a promise or a belief made without the intention of performing it. Intention ही नहीं था perform करने का. To deceive, and it must actually deceive with the party complaining of fraud having suffered damages due to it. So fraud के लिए a few essentials are either you have concealed a fact which is essential to the subject matter of your agreement, जो कि तुम्हें बोलना चाहिए था. Or secondly, तुमने कुछ lie कहा है about the fact, a wrong statement of fact. जबकि तुम्हें पता है कि that's wrong, not true. Thirdly, this must be intended to deceive the other person and it must actually deceive them as well. Jo party aggrieved hai and is complaining of fraud, it must have suffered damages due to it. So this renders the contract voidable, and this is also a bit serious because it is actionable in torts. If we have a class about torts, I'll talk to you about it. So this is actionable in the sense you can file a lawsuit for injuries as well. Fourth, misrepresentation. A wrong statement of fact made innocently without intention to deceive the party, which however induced the party to enter into contract. So misrepresentation or fraud में difference क्या है? Fraud में you are suggesting a fact which you know it's not true. Misrepresentation में you are making a wrong statement, but that's innocently. You believe it to be true. I believe that this rice is basmati rice and I'm advertising to you as such. Chahe it may deceive you or not deceive, it may induce you to come into this contract which you might have otherwise not done so. But will be misrepresentation, as I honestly believe it to be basmati rice. Whereas in fraud, I knew it was low quality rice, but still I marketed it as basmati rice. The aggrieved party may avoid the contract, accept but claim the difference. In misrepresentation, what you can do is you may avoid the contract completely. You can accept but claim कि अच्छा मुझे then low quality rice जितना ही price देना है तुम्हें. But where the party had means to discover the truth with ordinary diligence, the contract cannot be avoided. अगर कोई ऐसा misrepresentation कर रहा है जो कि बहुत common चीज है, he is giving you a rotten mango and says कि नहीं मुझे तो लगता है कि this is a fresh mango. You have the necessary means to discover the truth that no, this is not fresh, but you still chose to go ahead. In such cases, the contract cannot be avoided. This defense is only for misrepresentation. It's not available in fraud, right? Notice mere silence as to facts likely to affect the willingness of a person to enter into contract is not fraud. Let's say you ask me, I have a car which I know to be defective. I know it does not work very well, and I try to sell it to you. I don't really say कि it's in peak condition, and you don't really ask from me. You buy the car and go away. So I stayed silent, mere silence as to facts likely to affect the willingness of a person. चाहे कि तुम्हें लगा हो कि this is a car that's perfectly fine and working, but you didn't even ask me and I didn't confirm anything. So this is silence and this is not fraud. But if it is the duty of the person to speak, silence may amount to fraud. Suppose you ask me, if you do not deny it, I will assume this car is perfect and then I'll buy it. I do not deny it, I stay silent. Here, the silence is actually not silence, it amounts to speech, and that will amount to fraud. We have a few questions regarding the same. So, will be the last set of questions in today's class. It is essential to the creation of a contract that both parties should agree to the same thing in the same sense. Mutual consent, which should also be a free consent, is the sine qua non of a valid agreement. And one of its essential elements is that a thing is understood in the same sense by a party as is understood by the other. Simple basic things. Contract होने के लिए both parties should agree to the same thing in the same sense, जो कि सबसे important part and the thing that makes a valid agreement. And ये ऐसा होना चाहिए कि the thing is understood in the same sense एक party से जो कि दूसरा party समझ रहा है. So not only consent but free consent is provided in section 10. क्यों? Complete validity of a contract होने के लिए consent को free होना पड़ेगा when it works without obstacles to impede its exercise. When there is no consent or no real and certain object of consent, there can be no contract at all. Where there is consent but not free consent, there is generally a contract voidable at the option of the party whose consent was not free. Voidable in the sense कि contract तो है, but चाहोगे तो easily उसको void declare कर सकते हो, and you will not be sued for breach of contract. So a general averment that contract was not freely obtained is not enough. तो मैं ऐसा नहीं बोल सकते कि हाँ मेरा free नहीं लग रहा था मुझे. You have to set up one of the vitiating elements such as fraud, which includes false assertion, active concealment, promise without intention of performing it, any other deceptive act or any act declared as fraudulent. So contract free consent नहीं था. ये prove करने के लिए you will have to set up one of those vitiating factors which I talked to you about. Coercion, fraud, misrepresentation, undue influence. वो prove करने के बाद ही you can say कि अच्छा मेरा free consent नहीं था. In order to constitute fraud, the act should have been done by the party to the contract or by any other person with his connivance or by his agent and with intent to deceive the other party thereto or his agent or to induce him to enter into the contract. Already I've talked to you about the definition. There is no duty upon parties to speak about facts likely to affect the other party's consent to the contract. Mere silence does not amount to fraud unless the circumstances of the case show that there is a duty to speak or silence is in itself equivalent to speech. I talked to you about the note. On the other hand, misrepresentation falls into three categories. Firstly, a statement of fact which, if false, would be misrepresentation if the maker believes it to be true. You are making a statement of fact which is false, but I believe it to be true innocently. So that will be misrepresentation. But which is not justified by the information he possesses. मतलब तुम believe कर रहे हो, but तुम्हारे पास कोई information नहीं है कि अच्छा actually prove कर सको what you are believing. So it is obvious कि तुम जो believe कर रहे हो false है. But still you had not intended to deceive anyone. Secondly, a breach of any duty which gains an advantage to the person committing it by misleading another to his prejudice, there being no attention to deceive. No intention to deceive is a fundamental difference between fraud and misrepresentation. Please keep in mind. And causing a party to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement, even though innocently. Not really relevant. Which of the following statements correctly depicts the essentials of misrepresentation? First option. A misrepresentation is a positive statement of fact which is made or developed by a party to a contract and is untrue. Clearly, it's the right answer. You are making a statement of fact about whatever you're selling. It is a positive statement of fact and it is untrue. Let's go to the option number D. Misrepresentation is a negative statement of fact which is made or adopted by a party to a contract and is true. That's false. The fact has to be something positive about your product, but it has to be untrue. The fact, otherwise it will not be misrepresentation. Let's look at D and C. Misrepresentation and false representation do not mean the same. They do mean the same. If one party has induced the other to enter into a contract by misrepresenting, though innocently, any material fact, especially within his knowledge, the party misled cannot avoid the contract. This is wrong. Once you understand that you have been misled and misrepresentation has occurred, the contract is voidable at your option. So option B and C and D are ruled out. Option A is the correct option. Consider the statements given below and answer which one describes a fraudulent act. The expression fraud means an intention to deceive, yes, whether it is from any expectation of advantage to the party itself or from ill will towards the other is immaterial. A fraud is an act of deliberate deception with the design of securing something by taking an unfair advantage of another. It is a deception to gain from another's loss, true. Fraud arises out of deliberate active role of representator about fact. All of these options are true. 1, 2, 3 are correct. This is basically a few questions of each passage will be easy. They will probably be about which of the following statements are correct, consider which is not correct. And the other questions will be about issue-based ones. 73rd. Which of the following statements is correct? Fraud is an innocent wrong, whereas misrepresentation is an intentional wrong. This is completely reversed. Fraud is intentional, misrepresentation is innocent. Option B, the principal difference between fraud and misrepresentation is that in the former, which means in fraud, the person making the suggestion does not believe it to be true. And in the latter, he or she believes it to be true. So definitely in fraud, the person is knows that what he's saying is not true, but he's still saying it. But in misrepresentation, he believes it to be true. So option B is the correct one. Let's look at C. In fraud and misrepresentation both, it is not a misstatement of fact which misleads the promises. Wrong. It is indeed a misstatement of fact which misleads the promisee. I hope you remember the person making the promise is the promiser and the person to whom it's being made is the promisee, just like offerer and acceptor or offeree. Fraud and misrepresentation both are innocent wrongs. Wrong. Fraud is not innocent. So option B is the correct option. Mr. A sells a car to Mr. Y, his childhood friend, with knowledge that the car is defective. So Mr. A, who is selling the car to Y, knows that the car is defective. Before buying the car, Mr. Y says to Mr. A, if you do not deny it, I shall assume the car is perfect. A says nothing. I had already talked to you about this example. In the light of the statement, decide the liability of Mr. A. A's silence is equivalent to speech, hence a misrepresentation. No, the silence, when you do not say it, it is something that you know is not true, but you are not saying it. So here the mere mere silence does not amount to fraud unless the circumstances of this case show there is a duty to speak. Here there was a duty to speak. The silence of A amounted to speech. So that is why there will be fraud. A is not liable to fraud, but for misrepresentation, again wrong. Liable for both fraud and misrepresentation, wrong. A's silence is equivalent to speech and hence a fraud. True. Option D is right. I remember when I had practiced this set for the first time a year back, I had chosen the option C. A is liable for both fraud and misrepresentation because I was not clear that they are both different things. I thought a person who's committing fraud is automatically committing misrepresentation in the same way. But no, fraud and misrepresentation are completely different things. They cannot actually both be occurring at the same time. Fraud is when you have the intention to deceive. Misrepresentation is when there is no intention to deceive. There is an innocent fault. The last question is, in which of the following statements will a contract not be voidable at the option of the party? When a party takes consent by fraud, here the contract will be voidable. We know that. When a party takes consent by misrepresentation, yes, the party whose consent was taken by misrepresentation can void the agreement. C, a contract entered by fraud and misrepresentation is neither void nor voidable. This is wrong. Yes, it can be voidable. So what the question asks is that contract will not be voidable at the option of a party. In option A and B, we have seen that yes, it will be voidable. Option C is incorrect completely, as it is saying that it can never be voidable. So option D, when silence amounts to fraud, but the other party whose consent was taken had discovered the truth or had the means to discovering the truth with ordinary diligence. So here, what the see, this is a foreign concept. I already talked to you about this in my previous slide, but this is something that's not exactly mentioned in the paragraph, if I believe. So what he is saying is, if there is a process or the way of understanding the truth with ordinary diligence, as I had cited to you about the example of a raw, of a fresh or a rotten mango, if you have the necessary capability to decipher what the truth is, and you've actually not done so, then you cannot claim the option of avoiding the contract. So that's why option D is right. The party whose consent was taken had discovered the truth or had the means of discovering the truth with ordinary diligence, and yet they chose to go ahead with the contract. So of course, such a contract will not be voidable. I had a few more things about mistake as well as force majeure, but I don't think the time will permit. Yeah, so does anyone have any doubts about fraud and misrepresentation from these questions? All right. So contract is, of course, a very vast subject. I've touched upon a few parts of it. For example, I talked to you about the validity of a contract, the building blocks of a contract, when the contract is invalid, all the four factors. We talked about the factors such as, firstly, competence of parties, where we talked about the person had to be of age of majority, of sound mind, as well as person who is not expressly prohibited from completing a contract. Secondly, we talked about lawful consideration. The consideration and exchange of the contract must be lawful. Thirdly, we talked about lawful objects. We discussed a lot of agreements which are void because they're in restraint of a lot of things, or they're uncertain, and so on. Fourth, we talked about free consent, under which we discussed there are a few vitiating factors such as coercion, undue influence, fraud, and misrepresentation. In such circumstances, the consent is wrong. And the last factor was that the agreement must not be something that's void in law. So with this, we've come to an end of today's class. Anish? Yeah, so I hope there are no residual doubts.
No, sir, it was a very good session, sir. It was very conceptually clear. I felt you were very concise.
Thank you so much. If I get another chance, I'll go ahead with a few more things some other day, because contract, as I said, is vast. I did not touch upon a lot of things. For example, specific contract of bailment, pledge, agency, indemnity, and so on. Wagering agreements, contingent contract, and of course, two more things which I had: mistake and force majeure. So we'll see if we can do that later on.
Just a small thing. So how do you have the classes? Like, do you have it online on your portal, or like what is the system? If you could just say, guide us.
Yeah, I would not have a lot of idea about that. Anish? All right, I'll reach out to him and I'll make sure that you come to know it.
Okay, sir. Thank you so much for the exceptional session. Thank you.